Just invite you to take your seats, please. Thank you. I apologize again for the delay in the break and for by halving it, the tea break that you had. I was told that the coffee was cold because we started late, but it's okay because the drinks after this need to be colder. So there was just a prelude to our reception after that, and I just want to do a shout out to Rajah and Tann Asia. Thank you so much for sponsoring the networking reception that we have after this. They very generously agreed to that. I assure you it was not an entry price for Patrick to be on the panel later, but he very generously agreed. So we moved from opening remarks by Minister Tong, who actually informed us of the new rules that were gazetted at 5 p.m. last evening, and I encourage you all to download the amendments that we had. And then we had a very insightful thoughtful address by Scott and a nice fireside chat with Justice Ramesh. So now, to really bring things hotter and warmer and a wide range of topics that Scott has agreed, can I just invite Scott back as moderator for this final panel, and I'll leave him to introduce the panelists. Scott, please. Sorry. Yes. Thank you.
Well, I should begin by apologising for making the coffee cold, but I promise not to make the drinks at the end warm. I think I've learnt that much in my time. So we are scheduled to finish by 5:30. This is to be an interactive panel discussion, and so just as we did before with the fireside chat without the fire, you're most welcome to ask questions, and there could also be questions online, in which case Lawrence will signal that to me. So may I begin by introducing the esteemed panel today. On my very far, my left, your right, Judge Sontchi commenced his term on the SICC in July this year, and prior to that, of course, was in practice in the United States in major restructuring proceedings, but of course was notably appointed as a judge of the US Bankruptcy Court in the District of Delaware in 2006, and designated Chief Judge for 3 years to June 2021. So Judge Sontchi, of course, very regularly speaks at international conferences. He is, of course, a member of INSOL International. He's a member of the III and the Judicial Insolvency Network, as we just heard earlier today, the American Bankruptcy Institute and the National Conference of Bankruptcy Judges. He lectures also at the University of Chicago Law School, and I think he's going to have a very busy roster as he now makes his way more deeply into his work in the SICC. So welcome, Judge Sontchi. Corinne Ball, just to my immediate left, is a partner at Jones Day with nearly 40 years of experience in business finance and restructuring, and of course has always had a very strong focus on very complex corporate reorganisations and distressed acquisitions, both court supervised and extrajudicial. And although these cases are now perhaps to be said from the last financial crisis or the last cycle, of course, Corinne was involved very heavily in some very significant matters, including the City of Detroit. I guess you'd describe that as a restructuring or a bankruptcy, and also...
City lives.
A city.
It drives.
And also Chrysler, and many, many other matters, of course. Corinne has very senior leadership roles within her firm and has served as a director of the American College of Bankruptcy and the American Bankruptcy Institute, and is a member of the III and of course also of INSOL. So welcome, Corinne.
Thank you.
Patrick, I'm sure is known to everybody in this room and many people online. Is the managing partner of Rajah and Tann here in Singapore and the vice chair of Rajah and Tann Asia. Patrick has over 3 decades of experience handling contentious and non-contentious matters and still is very actively involved in practice. Patrick's acted in some landmark cases, Hin Leong, Nortel, and Lehman Brothers, and in 2018 was admitted as a fellow of the American College of Bankruptcy, and I believe was the first person from Asia to be so admitted, which is great recognition of Patrick's experience. Patrick's a member of the Professional Affairs Committee of the Singapore Academy of Law and a fellow of the Singapore Institute of Directors and a member of the Professional Conduct Council of the Singapore Ministry of Law and a very active member of INSOL and also the III. In fact, it was at one of those conferences that I first met Patrick, so welcome to Patrick. And then last but of course not least, Tai-Heng Cheng is Global Co-Head of the International Arbitration and Trade Practice at Sidley Austin, as well as co-managing partner of the firm's Singapore office. Tai maintains a very active practice, we were just chatting about that before we started here, and serves as both counsel and arbitrator in international disputes relating to commercial and investment arbitrations. He's also an advisor to companies, boards and governments just beyond, well beyond business disputes as well, and he's ranked as one of the top 10 arbitration practitioners in North and South America, and very enviously, I must say, in the under 45 by Who's Who Legal. So can I welcome Tai to the panel as well. So would you please join me in welcoming all of our panellists today. So we're going to traverse a range of topics, but I thought given the diversity of regions that we have represented here today, it would be good just to have a perspective, not necessarily just from Singapore. I think I might start with you, Patrick. You can give a broader perspective, but what trends and developments are we seeing in terms of restructuring and insolvency activity around the market, and what should we expect to see in the time ahead?
Hi everyone, good afternoon. Thank you for inviting me to this panel. In recent times, I think as Minister pointed out, we've been involved very heavily in many cryptocurrency cases in particular. And I must confess, I've never learned very much about cryptocurrency until the last few months. It's been rather cryptic to me. And it's amazing, one factor that was very common in the few companies I was involved in recent past, all the founders are in their 30s. I think you may have read of a recent acquisition of Freeport by a crypto billionaire who is in his late 30s as well. All right. I think the trend in terms of restructuring for Singapore and the region, in my view, is going to really grow a lot. In particular, because when we talk to clients in the recent past, right, there have been three things that our clients mentioned. One is Asia, two is ESG, and three is digitalization. And one remark that I came across watching YouTube, Minister George Yeo, previous foreign minister who is highly respected globally for his views, crystal balling ahead of time, mentioned something in the Russia-China communique, which I did not appreciate because I just glanced through it when it happened in early this year. If you remember, before Russia invaded Ukraine, Putin went to the Winter Olympics, and both governments issued a joint communique. And Minister George Yeo asked, what was in the last paragraph of the communique? And we all don't know. We just know something happened in terms of a cooperation agreement between both countries. But what's important in the last paragraph of the joint communique? Southeast Asia. I leave you to read the communique. I won't say more than that, but it, to me, shows the growing importance of Southeast Asia within Asia. And I can go on and on about ASEAN, but I'll leave it for now. I think that's a trend for insolvency practitioners in this region, and in particular Singapore, to watch, because Singapore, I think in particular, has a huge strength to play in this region in particular. Even if you leave aside North and South Asia, Southeast Asia alone holds a huge promise for insolvency practitioners moving ahead, and Singapore in particular plays and will play a huge role in that regard.
Corinne, the US normally is setting the trend in terms of economic or financial developments and distress and bankruptcy, so what are we observing or expect to observe in the US?
Well, I think there are three current trends which I would share with you. One is we are really beginning to focus on something we colloquially refer to as Chapter 11 light. And by that I mean working with our clients to make sure we totally understand what forum will best achieve their objectives and still retain some of the very beneficial aspects of Chapter 11's ability to sell assets, ability to borrow money, take discovery, and all of that you can now do without having a plenary proceeding. You can have a plenary proceeding elsewhere, and we are really focusing on, will this deliver? We owe it to our clients. Will this deliver the best result? And not to footnote a bit about the UK, but it also, we have to advise them about Gibbs, and where are we going to deal with that? So I'd say that's one trend. The second trend that we're seeing is really driven by the equity. It's driven by the sponsors. The sponsors are looking for new capital. They're in trouble. They need new capital for their business. They don't want to surrender ownership. So what we're witnessing is kind of an evolution of how new capital will come into a company. Basically, certainly not banks. It really is the evolution of private capital in order to supply the new capital that's necessary for a rescue. I'm going to give you a hint, Patrick. In the US, we don't use the word insolvency. We use the word rescue and restructuring. And I think this trend, finding a way to have new capital enter the picture. And you may all have seen it. One was Revlon, of great notoriety in the US, and the other was CERTA. But it's equity sponsors driving for additional capital to rescue their business, and they're very, very creative. And I think we're going to see more of that, and Patrick, I hope that Singapore will open the doors and find a way to accommodate this need for new capital and give the sponsors or the equity holders less fear of a restructuring. Because as long as they're totally fearful, they won't seek the tools early enough. And then the third trend, actually, Scott's already tipped that hand, so I don't even think you need to go into it, but it's mass torts. You know, how do you deal with a global problem where the court system is really inadequate to solve it one by one? So again, creativity, it resides with what we do. We do rescue and we do restructuring. And I would say those are the three big trends right now in the US.
And then Judge Sontchi, standing on the cusp of Singapore, but looking back from your career in the US with some distance now between you and your time on the bench, what are your reflections from that period, and what does that inform you about what we're likely to expect ahead?
Well, I'd follow up what Corinne said about mass torts, and it's an example of what a proper restructuring regime can do for an economy and the legal system. So bankruptcy was not built to deal with a lot of things. It wasn't built to deal with secured financing. It wasn't built to deal with dip financing, really. It wasn't built to deal with mass torts. But a flexible bankruptcy, I'm going to use the word, dirty word, bankruptcy, a flexible bankruptcy system and bankruptcy court that's true to the skeleton of the law, but is creative and commercial in nature, can adapt to a lot of different things, including a completely broken legal system in the United States to deal with mass tort cases, whether it's asbestos, and we sort of have figured out how to deal with that, but it's moved on to talc, it's moved on to silicone, it's moved on to sexual abuse, whether it's by groups like the Boy Scouts or the Catholic Church, and it's been able to adapt to those types of cases, basically because there is no other option. And that's kind of what we do in bankruptcy, right? We fix businesses, and sometimes we fix legal systems. So I think it's important going forward that judges maintain an open mind about adapting the rule of law that's been established and the procedures to not just run-of-the-mill, unsecured, big commercial enterprises that we had in 1978, to now secured debt with 3 tranches, to maybe broken liability issues with regard to mass torts. Crypto raises some very interesting and unique issues. I mean, basically, you're talking about a unregulated, uninsured bank who's taken all of its clients' money and put it in risky investments and not gotten it back. So that's a very interesting thing to deal with. So I think flexibility. As a judge, as I look back, I think the most important thing attribute I brought to it, well, a few things: hard work, knew the law, and was flexible. And I think those are 3 important things any judge should have.
I might just pick up on one thing, and I'll come to Corinne as well, and then Tai will explore with you what you're observing. But do you sometimes look back, because it seems as if it was almost only yesterday, the 2008-2009 collapse of Lehman financial crisis, do you look at that and think, we haven't learned, or how did we get here so quickly, or is it naive to think like that?
Well, here's the problem. This is the way the financial sector
Yeah,
works,
very
right?
good.
They all retired. Everybody in finance who was alive and working in 2008 and 2009 is now living on a beach somewhere. They're not actually doing, so all the lessons that were, except for Corinne, all the lessons that were learned are forgotten. They weren't passed on. You've got a whole nother generation of 35-year-olds that didn't live through that. So that was part of the problem.
Well, it seems a bit exaggerated even here in Southeast Asia. We, in the West and Europe, more so even the United States, did have a horrible time with the GFC. And some of the lessons we learned, hopefully, will be useful in Southeast Asia. But you here have enjoyed prosperity ever since the Asian debt crisis. You were insulated from the GFC. So while it may be there are still a few relics around in the US and in Europe who lived through the GFC and the ADC, I was here buying up assets like crazy for Wilbur Ross, Lone Star. But right now, let's think back. What was very signature about the GFC, and particularly in Europe? And Scott, a lot of your partners dealt with it firsthand. All the companies' capital structures were 75, maybe, Chris, maybe more. Short-term bank debt was their capital structure. The rest was equity and trade credit. And when you were faced with extreme risk and volatility and you needed new money, that wasn't the kind of investment banks wanted to make. So private credit came roaring out of private equity and really rescued Europe by providing new capital in a way that business could use it and letting the banks do what they do best, which is revolver and real short-term credit. But it took a lot of convincing that private credit was not necessarily a bad thing. People were very suspicious, but ultimately the capital markets and capital solutions pulled people through.
In my career, since I started as a baby bankruptcy lawyer in 1993, I think well, there have been a lot of changes, but the 2 major changes that really jump out to me were the creation of private equity and professional distressed investing. I mean, neither of those things existed when I started as a young bankruptcy lawyer, and they completely changed the face of how we do business.
Well, it seems like capital drags us into innovation.
Yeah.
It's a very interesting historical anecdote that on the day that Lehman Brothers filed for Chapter 11, INSOL was hosting a conference in Shanghai. It was the first time that a major conference had been hosted by INSOL in that city. And it's the, I guess, extraordinary part of that anecdote is that the conference had to be hastily reorganised and reconfigured live because most of the US practitioners and many other practitioners quickly left to jump on planes.
I was with Jim Peck. I don't know where we were, but I was with Jim Peck at a conference in the U.S. and he we're having a cocktail and he disappeared.
September 15th.
I said, where the hell did Jim go? He goes, he just got Lehman. I said, well, I'm not going to see him for a while.
No.
So Tai, you've got the great benefit of not just being anchored in bankruptcy cases at all in your arbitration practice. So what are your insights at the moment that are relevant to this audience from the work that you're involved in?
Well, you're right. It's really humbling to be on this panel with so many experts in bankruptcy. I have been involved in some bankruptcies, but just enough to be dangerous. Going as far back as American nuclear insurers in the early 2000s, I'm still alive and kicking from there. I still remember the lesson from financial crisis. I represented the Abu Dhabi Investment Authority against Citigroup, and I did Suntel, and I was an expert in the Nortel bankruptcy. So I don't profess to be an expert like you all, I just know enough to be dangerous. Standing both as an insider and outsider judge, one of the things that I've marveled about the bankruptcy regime or restructuring regime in the United States is just how practical everyone is in comparison to civil claims and so on, in just finding solutions to put capital back to work and to put people back to work. In the Nortel bankruptcy, when there were parties filling the courtroom all the way out of the courtroom in Canada, they had no problems at all coordinating the bankruptcy with the United States. Try doing that in a civil lawsuit and we'll be tied up in conflicts of laws litigation for God knows how long. So I think that really opens up an opportunity for Singapore, this is trend number one, to the extent that the SICC and courts here can adopt a practical, pro-business approach to restructuring. That will make Singapore an extremely attractive venue for insolvencies in the region, and I think the courts here are well suited for that. Singapore courts are well known to be commercially practical courts, and so it plays to the advantage of the bench here and the bar. The second trend I'd like to pick up on is really something that you touched upon, Patrick, which is the importance of Southeast Asia as Russia and China strengthen their bilateral ties. And I'd like to leave you all with one statistic that I think is going to be the single most important fact for the next 10 or 20 years. Most economists in the United States and in Asia agree that by 2030, China will be the world's largest economy. For everyone in this room, in all of our lives, the United States has been the largest economy by far. For the first time ever in living history, it will be a co-equal superpower with China, which I think, and they'll be roughly the same size, one ahead of the other, but not by much. And the next 20 years will be marked by acute contestation between two systems that are diametrically opposed to each other and have dramatically different views on how the world and country should be organized. Within that tension comes Singapore, which has built itself upon maintaining friendly bilateral relations with both the United States and with China for as long as I can remember. And insofar as companies in Asia may no longer feel able to go to the United States for restructuring because they feel pulled in one direction or another, Singapore provides a good neutral venue to pick up that work. And I might add, that's not just good for the Singapore economy, it's actually doing a great service to the world. Because in a situation where you've got contestation between two superpowers, any country and any legal community that can help restore commercial order globally quickly is doing a service to all the stakeholders involved in the commercial system. Let me just stop there with two trends. I have more, but I'll stop because I know we've got limited time.
No, I think the rest will come out, Tai, but I promise not to make the drinks warm, as I said at the start. Patrick, we've had a lot of discussion today about the reform process that's been underway in Singapore for quite some time, the opportunity that the SICC presents for taking things to another level. If you were putting on your advisory hat to clients and comparing and contrasting different options, what really are the strengths or the opportunities of Singapore and vis-a-vis other jurisdictions? A slightly unfair question given that you practice here largely. But also in thinking about that, where have we struck the balance and have we got the balance right between accommodating the rights and interests of debtors vis-a-vis creditors, or is that not a relevant consideration?
Yeah, the last point is always a question that we get asked after the 2018 reforms in Singapore, whether are we pro-debtor, pro-creditor. To me, it doesn't make sense to try and categorize systems into pro-creditor, pro-debtor, in as much as there's no point saying that your system is pro-creditor, anti-debtor, I don't think it's a case of an anti-debtor
No,
system.
it's whoever just lost
Yeah.
says you're pro the other side. So when I rule for the creditors, I'm pro-creditor. When I rule for the debtors, I'm pro-debtor.
Yeah. So it's
In the same day.
So the way you put it, Judge, exactly the point. I mean, it's very much as much as saying that you like the jurisdiction because it favors you, right? It's not the point. In insolvency, you're really talking about a collective solution, right? And that is always a skill set that insolvency practitioners must bear in mind. You're not in an adversarial system where you're having one party whom you're advising against one party on the other side, or even a few parties on the other side. It's a multilateral stakeholder situation with very different types of interests being represented at the table. All right? And that kind of dynamics that all of us experience, because most of us here are in this industry, it's something which you cannot just say, let's go pro one side or pro the other. So that's point number one. Point number two, that applies likewise to systems and jurisdictions. Right? A judge, when he or she sits to listen to a case, likewise needs to bear in mind the impact that one party asking for something may have on something else. Right? And that really is not really getting pro-debtor, pro-creditor again. It's very much doing justice, being fair, and as Tai himself mentioned, I think also being very pragmatic and commercial. So some of these solutions are not found in strict black letter law. And I think I saw it very much. I was much junior then when I got involved in Nortel and Lehman and watched how the US judges, the Canadian judges approached issues, right? And they looked at issues like saving time, saving costs, getting things done that hurt people the least. Right? Those are considerations which are not necessarily just a legal argument. It goes into policy, it goes into common sense, as simple as that. All right, and it goes into basically being fair. All right, so I think Singapore, therefore, has a huge advantage. When you look at the title, Singapore International Commercial Court, actually each word means a lot. So the fact that we have a Singapore branding is huge advantage for us because Singapore has a lot of intangibles and value to offer to the world, number one. International is, as we all know, the world is, in my view, getting smaller, and Singapore has a huge role to play, right, to make that happen within that small world that's become. Commercial is what Tai mentioned. Singapore people are fairly pragmatic. It happens at every general election. No matter what you may say, Singaporeans, in my view, are going to be voting pragmatically, regardless of their deep political discourse over dinner about how unhappy they are on some issues that the government has put in place that affects them or affects someone next to them. Come to the vote, pragmatism will prevail, in my view, generally, right, which will carry us across probably 60% thereabout, which is quite good already. That's what Jokowi is having in his prime, 62% rating. So I think pragmatism, commercial, and of course, court. You do not explain court. So the four words, I think are loaded enough in Singapore's favor.
Thanks, Patrick. So we've had Patrick's completely objective assessment of the Singapore model. And so, Corinne, you're advising clients in relation to different options and different offerings. And so in assessing the strengths and the opportunities or the disadvantages of different processes, what do you see perhaps that stands out with Singapore, or what might be missing from the system?
I think that you've touched on it a bit. We touched on it when you talk about model laws on group. There is no doubt in my mind that most enterprises are involved in more than one jurisdiction. So coming to a jurisdiction that is used to dealing with entities that are organized under neighboring or other states is kind of critical. Frankly, I think the UK has done itself no favors with the Gibbs Doctrine, but we're looking for what relief do you want, where can you get it, where is it the least expensive and the most efficient. And for instance, when I referred to Chapter 11 Light, in Chapter 15, there is no creditors committee. There hardly is any litigation. But if you need to sell assets or borrow money against assets in the US, you can do it. But if it's a group and the rest of the group is elsewhere, frequently, that's what we would do. In fact, it was another Canadian case. It's called Just Energy, which was a total U.S. disaster in Texas. Total. The winter storm destroyed all power lines in Texas. Gas lines were frozen. So everyone who was in that business was basically in total distress. Decided, we're going to file for a CCAA in Canada, because we don't want to be bogged down in litigation in the U.S., and we'll use Chapter 15. And they borrowed immense amounts of money on a DIP loan in about 3 days. They reorganized selling assets in the U.S. They sent all the money back to Canada to deal with the Canadian corporations and creditors, and it worked very well. I would say, Scott, the other one your firm was very involved in was Norwegian Air. You're using the Irish examinership because they wanted recognition throughout the Commonwealth and the EU. So it's kind of what objectives are you looking for? Where's the recognition? But I do think you have to be in a place that respects the enterprise, which is almost by definition going to be more than one entity. And Singapore, certainly being a regional hub, has dealt for many decades with companies that are organized in neighboring states. So you have the experience.
I think that's what Justice Ramesh was really referring to when he talked about forum selection, which is the reality in the U.S., right? The reality is you can pick probably any large organization could probably pick 30 of the 50 states to file a case in. And not all of them come to Delaware, not all of them go to the Southern District of Texas, not all of them go to the Southern District of New York. A lot do. But they go other places. And it's just lawyers being good lawyers, looking at the problem the client has and figuring out what legal regime, what procedures work best to solve the problem. Now, you have to respect certain things as a judge. You can't just sign everything they put in front of you. The most important to me is always due process. And a lot of that goes to notice to creditors and giving creditors an opportunity to be heard. But I don't think there's such a thing as bad forum shopping. I really don't. I've never seen it in my career as a lawyer or as a judge. So I think that's exactly, I think Singapore is hopefully, and more specifically the SICC, is going to hopefully be in a position to be one of the fora that people can look to and say, is this the forum that's going to solve my client's problem? And hopefully, if so, they're going to come here. And if not, they're going to go somewhere else, and that's okay.
And so, Judge, just on that point, in thinking about making the move from the US system to Singapore, it sounds as if that's certainly one of the driving considerations for you, and that opportunity to be involved in cases where that's a consideration or a driver. What else drew you to the Singapore opportunity?
Well, I was really, Ramesh is a great salesman. Don't ever get in an elevator with him. You're going to walk away with a car. Yeah, quit your job, come here. Okay. No, there were a lot of things. First of all, the people here are just so wonderful, and I love everything I've learned so far about Singapore. Of course, it's got problems like any place else in the world, but it's a really just fantastic country and culture, at least the little bit I've been able to learn about it. I was fascinated by the idea of helping create a restructuring opportunity, both as a court and as a culture, to help, I think, as far as I understand it, currently underrepresented economies in the restructuring world of Southeast and South Asia primarily. And using Singapore as this nodal jurisdiction to maybe change the game on how people think about restructuring, maybe people who've never even thought about restructuring when they have a distressed situation. And my experience has been over 30 years in the business and 16 as a judge, is that properly functioning bankruptcy systems and bankruptcy courts are good for the economy. They save jobs, they save tax bases, they help hold communities together, and they continue businesses that should continue, and they give a decent burial to businesses that shouldn't. And not every business should reorganize. Sometimes you just got to throw in the towel. Nobody's buying buggy whips anymore. Some things just aren't going to make it. And that's okay too. So so it was just, and plus an opportunity to do something different, frankly. I mean, I love being a judge. I would never have left Delaware bench if I couldn't still be a judge. But I've been doing that for 16 years, and my wife will tell you I get bored easily. I wasn't bored, but I was looking forward to a new opportunity and a new set of challenges, and this is it.
Can I courageously ask whether you've had a chance to look at the new rules yet that came out overnight and what impact they might have?
Well, am I allowed to say I saw them ahead of time? Okay, I saw them ahead of time. So I guess by asking that question, I answered it. I think they're fantastic. A tremendous amount of work went into them. And I think the two things that really jump out from a very, again, practical standpoint, statute/rules, is the ability for foreign lawyers to participate in a meaningful way, and the fact that virtually everything can be done virtually. So we're going to have the ability to do things remotely, which I think will help, especially if we're dealing in true international cases where we may have participants from 5 or 6 countries throughout the region, and the judge sitting in his living room in Delaware, and we're gonna figure it out. And it'll be a lot of 2 a.m. hearings, my time, but that's okay. So I think those are two just sort of high button issues that are very important.
Tai, can I ask you, a topic that sometimes comes up in the bankruptcy domain is litigation funding, and in some jurisdictions there are advanced systems. Is there a sense that that's an issue that comes up in arbitration situations or in the work that you're involved in, and do you have any perspectives on whether litigation funding has a place in the system? And then I'll seek some views from the other panellists on that.
So I have a rather entrenched view about litigation funding. I recognize it's not a universal view, so I shall characterize it as idiosyncratic. In my view, when a dispute has arisen, where the losses have fallen, I view as sunk costs in the way that a private equity person would view what's happened in the past as sunk cost. The decision going forward is how much do you have to invest in time and money and management bandwidth to get what potential return if you were to pursue dispute resolution, whether it's litigation or insolvency. In that sense, what you have is an asset that is commercializable. And what litigation funding does is allows you to borrow against an asset. It's a contingent asset, but an asset nonetheless. So leaving aside questions of funding for personal injury, domestic violence, and other personal type torts, when it comes to purely commercial claims, I'm fully in favor of a financial system that allows parties that hold a litigation asset to commercialize it. It's simply allowing for the movement of capital and of assets from people who want to spend money to people who need the money. And if that allows dispute resolution to occur as a means of monetizing your asset or trying to, then all the better. As I said, by way of disclaimer, I realize this might be a not universally shared view, but it is my view. From that standpoint, I think the introduction of litigation funding in any commercial legal system is a positive. Now turning to the reality of the trend. The early entrants in litigation funding some half a decade or more ago made supernormal profits because they were pioneers. With the massive amounts of capital injection all around the world until this year, that has caused a situation where too much capital is chasing too few opportunities in all asset classes. Litigation funding is attractive because it is non-correlated to the equity markets. And so for any large fund with vast amounts of capital to deploy litigation funding is something they look at. As a result, however, of not having enough good cases to fund, I think some funders are making poor decisions about what claims to invest in. I understand perhaps why it is happening, because fund managers have pressure to deploy capital. That is how their performance is measured by their investors. No investor wants to know they've tied up capital and it's not been deployed. But I suspect in 3 to 5 years, when we start seeing the results of those litigations or lawsuits, there will be a reckoning as to whether or not the funding decisions have been properly made, and I think there will be a correction in the litigation funding market globally as a result.
You know, one thing, litigation funding can be tricky if you're the judge who's deciding whether to allow the funding and the judge who's deciding the dispute. So they're pricing it based on what they think you're going to do. You probably have a pretty good idea what you're going to do, but if you let them know through, you know, not saying that's too good a return or that's not a good enough return, you're in a really weird spot. And I had this very specific example in a case called Downey Financial, which was a savings and loan from the 2008 crisis. And I had a matter under advisement. I was working very diligently on it, and you'll come to know this in Singapore. My opinions are way too long, so they take a long time to write. And the debtor ran out of money, and well, the trustee ran out of money, and they had to go get litigation funding. And I decided I was not going to put my thoughts about where I was headed into the equation, and I just approved the litigation funding, and I issued the decision 2 months later, and the funder made a just gigantic profit on the matter. So it can be a tricky thing to do as a judge. That's the only time that ever came up in my career. But we don't see a lot of litigation funding in bankruptcy court in Delaware, or did not. I'm not there anymore. But that was one situation. It was DIP financing, but it was really litigation funding. I guess DIP financing is litigation funding.
Right.
Yeah, it's a cousin or something.
So if I could just tag on to that, if you have a situation of a sophisticated claim holder or client and a sophisticated funder, both of them should be fairly clear-eyed about the upside potential and the downside risks given the current constellation of facts. In that sort of perfect market, I would suggest that where the hand has been tipped, the return that a funder should expect to extract from the client would be lower. Whereas if you fund at time T0 and the risks are greater and the length of time is longer, so IRR drops, then the return you expect may well be higher in absolute yield terms.
I like to meet the lawyers you hang out with that are clear-minded about risk.
Well, you know, I started my career as Solomon Smith Barney in 1997. That may explain a thing or two.
Okay.
Patrick, is litigation funding in bankruptcy cases a feature in Singapore?
It is, but I would say we encounter more rescue financing for the restructuring as opposed to the litigation. I think most of the practitioners here, would attest to the fact that most of the time we try and achieve amicable result from the pending cases rather than seek litigation funding. I think most of us approach it fairly practically, in the sense that, look, at the end of the day, if you're going to litigate over this, it's going to take a lot of time. It's going to get into the way of the restructuring. So quite often, there's a resolution achieved pre that, and it's usually arrived at much earlier, right, at a much lower cost. The return may not be as high. So there's a compromise, obviously, right, in a restructuring where if you, the other side knows that you're running out of funds, and your option is to get a litigation funder or rescue the whole entity, the whole group, and move on. Right? They will know that they have an upper hand in the bargaining. So there's a bit of compromise on that front. I think regionally, I'm seeing more litigation funding in the region. All right? And the reason why I think in the region there's more litigation funding, interestingly, is because the legal systems in our region are less predictable. So there's no issue of what Judge just talked about. No one knows what's going to happen. In fact, even if you think you've got a good case, you might not have a case down the road. Right? So I think when you price in risk in that kind of context, interestingly, there's more to play with in terms of getting a commercial deal to fund. Because the guy who thinks he's got a good return will look at it from many different perspectives. It's not so straightforward an equation. I think in Singapore, it's perhaps a bit more predictable in terms of the opinion you could get from a law firm, whereas it would be less so in the region. So we actually see more funding in places like Vietnam, in Thailand, in particular, in Indochina. We actually see quite a bit of interest in funding litigation in those areas. I was going to make a point before we moved on that Judge made about the rules. I saw a very quick look only because I had no a chance to preview it. My impression is also the same, that the fact that foreign lawyers are involved will be a huge change in dynamics for the restructuring community here, avoiding of insolvency from now on. The fact that in the past we look at the foreign lawyer as another counterpart operating a parallel proceeding and then instructing them, talking to them like counterparties, I think will change when that foreign lawyer can be with you in court, right, in the same hearing. So I think that's an interesting dynamic which I'm still thinking through how that will play out, but quite clearly a huge change in dynamics. The second thing I think which struck me reading the rules is akin to the SICC rules last year. I think there will be a lot of flexibility in terms of how the rules will be interpreted and how lawyers can argue innovatively as to what can be allowed. Because whatever is not stated to be disallowed is allowed. It can be, as long as there's some good reason why it should be done, there's no reason why it should not be done, is how I would look at it. And I think that's going to be another huge plus. Instead of being constrained by what we perceive as procedural rules and steps. Right? I think the way I read the rules now, they provide a lot more flexibility, which I think will be great for the
Does that mean your judges will have more discretion now that you do have such an accomplished bench with a special purpose?
I think in an interesting way, we have already seen the changes in the way the courts here have approached restructuring even before the SICC was set up for this purpose. I think we already started to see some evolution. And I think the setting of this SICC and the rules for insolvency and restructuring, in a way, to me, it's a combination of the years of preparation that should have been put in to change mindsets of both the practitioners, the lawyers, the accountants, and the creditors. It's an ongoing process, I think. Yeah.
Corinne, can I explore a bit further with you the issue of mediation and the way that you're seeing mediation, especially in the US market? And I mentioned the Texas two-step, you've mentioned mass tort matters. That's obviously one area where we hear lots of discussion now about mediation, but clearly it's occurring more broadly. So across the survey of matters that you've been involved in and that you see on the horizon, what is your perspective on the way that mediation can help or facilitate the process?
I would begin with kind of the observation that in the United States, I would say the most effective mediation in the restructuring rescue world we have developed using judges and retired judges from the bankruptcy bench as our mediators and using sitting judges. That has made such a difference because they have a very good sense of what your alternatives are. And I think of mediation, and Tai, I would defer to you. You really need someone that understands risk management to be an effective mediator. And on the company side, time is always our enemy, almost always. So to the extent that mediation permits a less expensive resolution and a more efficient and time-saving resolution, you do want to explore it. But by the same token, if you've got a very, very well-funded, the one thing about mediation, and Patrick, you've nailed it, when it's multilateral, it's highly specialized. Most mediators, when you go into the litigation world, are used to a bilateral world, A versus B, each has a case, each has a defined set of risks. In our world, it's multilateral, and you really have to get along with multiple stakeholders. And if you press on this side, it will have a consequence over here. So I think we found that this trend, having judges and retired judges, has been particularly effective with members of the restructuring bar as an effective way to resolve particular issues. And Scott, it goes way beyond. It goes way beyond mass torts. I would say the judges have now been doing it for quite some time. And they've even done it. We had a great regulatory issue in the Texas energy cases. You know, could you attack the grid? Could you sue the grid? And that all ended up in mediation, judicial mediator, and was resolved in 100 days. suing a regulator, going up through the appeal on the grid that serves all of Texas, would have taken years. So I think that has really recommended it. But I have to say, the regulator, Tai-Heng, was beside him. They were beside themselves because they'd only been in bilateral litigation scenarios. So I would turn it to you as to what you think the future is of mediation, because you probably see bilateral and multilateral.
Well, you're right. In bankruptcy, what stands out in mediation, it is multilateral. And you may or may not agree with me, Lane Phillips is one of the best bankruptcy mediators I've seen.
Oh, he's spent a lot of time in Delaware lately. And a lot of time actually with Judge Drain.
So in Sun Edison, he was the mediator, and literally we booked down the entire hotel in Midtown Manhattan, and all the creditors were in separate conference rooms, and he and his team just spent the day running between rooms. And I've never seen such an exceptional mediation session.
I've never met him, but I've heard his name so many times.
His hourly rate is higher than the top arbitrators, but he's worth every penny, in my view. So
now that I do a little work on the side, I'm all in favor of high hourly rates.
but returning to Scott's question about the role of mediation in the bankruptcy or insolvency regime in Singapore, I tend to look at the ecosystem as a complete ecosystem rather than a siloed arbitration, mediation, restructuring. And I think Singapore's push into restructuring is really very timely because it brings together these different strands of alternate dispute resolution into one node, as it were. If insolvency takes off, as I expect it should, that should then create a boost in market demand for savvy commercial mediators in precisely the sort of multilateral dispute resolution that you talk about. And then, of course, on the side, you'll have arbitrations. That's tougher to get all the parties to agree to an arbitration. It's hard for me to imagine all the creditors of Sunet, for example, agreeing to arbitrate. But in Sunet, I did bring bilateral arbitrations and caused a lot of trouble, but made my client whole. They were happy. And so I expect complex insolvencies here to also have ancillary arbitrations by creditors or others who find creative ways to take themselves out of the restructuring process. It's not easy, but it can be done.
How does arbitration compare to mediation in terms of timeline and expense?
Depends on the arbitration you bring. So if I may be allowed a war story, this is now long enough ago. In Sunet, we saw the bankruptcy imminent. We filed an arbitration, went to New York Supreme Court and got a TRO from the judge. I then called up the Wall Street Journal, which published the fact that I had temporarily frozen all of Sunet's assets with this order. Sunet's stock price dropped by 50% the next morning, and I had settled my case by the afternoon. So I would say properly done arbitration can be incredibly efficient.
Kudos.
You know, that sounds like a crime.
I'm still a member of the bar.
Mediation, I think mediation is particularly helpful in bankruptcy situations, and but not every case. It's not a panacea. It's not one size fits all. It's not for every case. Sometimes you have to allow the parties to fight a little bit, to take a little discovery, bang around with a couple motions, and before they're ready to sort of sit at the table. The challenge is always in bankruptcy, but it's also an opportunity, is the multilateral nature. So I have done, in Delaware, I did several mediations as a judge for other judges, and the bilateral disputes were so easy. You know, it was a day, maybe 2 days. One day in person or on Zoom, and then maybe emails for a couple days. It was usually pretty easy to put together. The multilateral ones take months. I mediated the dispute between the committee, the official committee of unsecured creditors, and the debtor in Mallinckrodt last year. And that took from, I think, May to October before we were able to finally, get an agreement, which greatly made it much easier for the debtor to get its plan confirmed, which the debtor did. But I also at the same time tried to mediate with other parties and the debtor, and there was just no way to remotely get there. So, it's a little bit like, if you, as a mediator, I think if you settle 50% of your cases within a couple months of starting, I think you're fantastic. That's a huge
Let me ask you
success
something.
rate.
It may not be the same, Patrick, in Singapore. But in the U.S., one of the things you're always worried about in a multilateral is waiver of legal privilege. What you're constantly worried about it, but you need transparency and you need accurate facts in order to get to a resolution. And one of the features that we rely on heavily in restructuring and mediation is being able to get an order that in essence says this exchange of information is incredibly confidential, can never be used, but equally importantly, and I haven't seen the orders tested, it's not a waiver of privilege. And somehow that brings people closer to the candor that a resolution takes.
That was an issue in Delaware over the last couple of years with Boy Scouts. We actually changed our local rule. I was the head of the local rule committee in Delaware, or the judicial head of the local rule committee, which meant everybody else did the work, and I said yay or nay. But we changed the rule to have a rule specifically, I think it's 9019-5D, which sets out in a rule what exactly the confidentiality provisions are, because you do have to be careful about what you can and can't do, either signing some order or passing some local rule with the attorney-client privilege. So if anyone's interested, I suggest they have a look at that. Again, it's 9019-5D of our local rules in Delaware, because it kind of lays out what I think, if we didn't have a local rule, would be in all the orders that were being signed, in order to be consistent with some rules that the judge in the Boy Scout case sort of came down and said, no, you have an overbroad sense of confidentiality here, and I'm going to claw back and allow the other side to use some of the information they got in mediation, which was horrific to the debtor that they were being allowed to do that. So it is a very tricky issue.
You must have tried to put rules of engagement, Tai, before you start down that road?
Yeah, I think for us here, we are quite clear that when we do mediation for insolvency at the moment, that it's usually on bilateral matters rather than multilateral. That's point one. And when it comes to bilateral matters, usually it's quite clear that the confidentiality is absolute, so nothing is going to be used outside.
Are you using a court order, or is that just practice?
It's one, practice, and two, is an agreement that parties sign.
Oh, the parties sign.
Before they enter the mediation, and then the mediator is taught in mediation school to emphasize that at the start in bold, that it is entirely confidential, and therefore it can be candid in whatever you say, and nothing will be used against you outside the mediation. But I was going to add that in terms of the possibility of mediation moving forward for Singapore, I think one of the issues we have here, which I see in the US, you have a lot of very experienced bankruptcy judges. Not that we have none, we have, right? But there are few. And those who are currently retired are not specialists, right? And the few we have who have really become specialists, I don't think they'll retire so soon. All right? But that, to me, is one factor, because I think the fact that you have a judge mediating, I found actually is very helpful to the parties, as opposed to just a practitioner, even though very experienced, but I think there's some moral authority that the judge has, even though it's a mediation, it's not binding. So that's one. Two, I think what's interesting is there is some, when I speak to many practitioners, and myself included, right, there's a bit of a mindset shift that we need to have, which is that we think mediation can't work in a multilateral setting. We almost think it's a waste of time. It's going to take a long time to get so many parties. As you said, in the building in Manhattan, we may not have so many parties, but we'll have enough parties that makes people get worried. So it'll be quite interesting to learn more about how that can be done in a way that's fairly efficient, because I think clients will get worried when they think that this mediation is going to be dragged out, it's going to be costly, and it might not be binding, and people can walk out and we're back to square one. So there's that mindset shift that we need to, myself, get educated as well, because I'm myself not experienced in doing this kind of mediation, although I read about it, and I know it's been happening in the US perhaps for the last 20 years, perhaps already.
More intense than 10,
Yeah, yeah. So whereas in Singapore, I would say that hasn't, even in the region, hasn't quite taken off. Although if you think about it, Indonesia, which we do a fair bit of restructuring, actually is ideal to do mediation because the court process there is not currently still a viable option for most cases, bilateral or multi.
It's an important point, Patrick, and one of the drivers for setting up the INSOL ADR colloquium was exactly that reason, to start to try and increase the understanding of mediation and arbitration and alternative dispute resolution tools, because it's actually okay for us to sit here talking about it, even arbitration, with an assumed knowledge, but it's just not universally the case. And when we look at especially emerging and developing economies trying to leapfrog ahead from 100-year-old insolvency and bankruptcy systems to something that's modern, talking about mediation is the same sometimes as talking about the arrival of some of my ideas from outer space restructuring, which I promise not to taunt you with on the panel discussion. I'll open up for questions briefly because I'm keeping an eye on the clock, and if Lawrence has any questions from online, he'll give me a signal, otherwise I'll steam on. But Judge, I'm interested to have your perspective on what you've experienced in court-to-court cooperation and communication. You've been in the best position to perhaps experience that more than the rest of us. And so what has been your own experience as a judge?
So, so ignorance is bliss. So I was very new at the judge job, and I had a case called Pope and Talbot, which was a cross-border case with a CCAA in Canada and a Chapter 11 in Delaware. And they had assets. It was all because of the financial crisis and the housing collapse, because they were a timber company. So they had lots of timber, but no one to sell it to. And I got a call. I can't remember if it was the party's idea. I think I just got a call from the Canadian judge, the late Justice Bruner, and he wanted to have a conversation. And I said, well, I'll talk to anybody, sure. So we started this court-to-court communication without telling anybody. And it was very effective. And then all of a sudden we were doing joint hearings. Parties were appearing in front of me and parties were appearing in front of him on identical motions, and he would hear they would make their presentation to him, and they would make the presentation to me, and then we'd take a recess and talk on the phone and then come out and rule. And it was like totally terrible. I don't say it was terrible. It was great, but it was also sort of cowboy justice. I mean, we were really just kind of trying to make the case work. And the parties were aware that we were doing the hearings, obviously, and they were aware we were communicating. But it worked tremendously well, and I've had other cases involved with court-to-court communication with Canadian judges. I had one with a Cayman Islands judge who was actually in England. That's the low-hanging fruit of court-to-court communication for U.S. judges, right? We come from basically the same common law system. We speak basically the same language. Time zones aren't a problem. Language isn't a problem. Legal systems aren't a problem. But I found it very useful. And of course, Nortel had a multi-week simultaneous cross-border trial between Delaware and Canada that was highly successful. I think that was the high watermark of cross-court communication. I think maybe it scared some people. We haven't seen anything quite like it since, but and maybe we'll never will. I don't know. But I think court-to-court communication can be very helpful.
Didn't you have there was a protocol in Nortel
There was
as to
a protocol.
how it worked that all the parties got to comment on?
Yeah, that was
to provide
I
confidence.
thought it was fabulous.
Yeah, well, I just was only commenting in that you haven't seen something like it. We used to do protocols, and one of the ideas behind the GIN guidelines and the modalities, which are almost more important than the guidelines, are to get away from having to negotiate a new protocol every time in every case. Delaware adopted them into our local rules, but I don't know if they've been used, frankly, since we did that in 2017. It depends on the cases. Some judges are very reluctant to do it. I had a case years ago where I wish I had done it, but it would have been it was a Japanese. The other case was in Japan, And I was getting a lot of allegations in my court about what was happening in Japan. And I think it would have been very helpful to have a conversation with the judge and find out what was happening in Japan, because I was getting two different stories from either side, and depending on which one I believed, it really affected what I was going to do. And I didn't have the option at that time to do that, and I didn't know quite how to get around, this was ages ago, how to do it. So I think today, if I were in that same situation again, I would use the tools we have and the relationships that I've established in order to reach out to that judge, and I think it would have been a better result for the parties if I had.
Corinne, what have your experiences been in bringing matters before courts? Have you had situations of joint or simultaneous hearings?
I have. I had the privilege of appearing in front of one of the pioneers of court to court, which was Justice Farley in Canada. So we did it in Cadillac Fairview, we did it in Olympia, New York. Where we ran into the rocks was trying to use it in the UK. They were just not as welcoming. It was too formal. But as you've mentioned, Judge, with Canada, it was relatively easy. I then was a trustee on a fund that had gone bankrupt, and it had a Chapter 11 pending, and certain of its subsidiary funds had liquidations pending in the Caymans and the BVIs. So it was the same thing, but it was 3 judges. And it was very interesting because the Cayman judge was much more open to communications, and the BVI judge had never experienced it. So it's kind of bringing people along. It's kind of why, Patrick, I turned to Singapore. You're used to it, but you deal with it. You deal with Indonesia. That's civil law, right? Yeah. So I mean, how do you combine cross court when you're dealing with, a civil law and a common law? That's an experience I haven't had.
The short answer is there's no communication currently between Indonesian courts and Singapore courts. But you are not wrong to say that I think the practitioners here have adapted quite well in terms of advising on matters which cross, and in fact the laws are quite different in terms of procedure as well as substance between Indonesia and here. The businessmen and entrepreneurs there talk among themselves as to what they think should be done cleverly to get the ultimate outcome for them. Not optimal, ultimate outcome for them. So it's quite interesting in all those kind of dynamics. If you act for foreign creditors who are not used to those dynamics, you're right, there can be a clash. And I see it less of a clash between the legal systems as a clash of culture, right, and a clash of the institution's approach to things rather than the two systems. So I rarely see the real substantive issues of law becoming a huge issue in the restructuring. It's actually the underlying issues, and the legal issues become the manifestation.
I'm going to open it up for questions, and so I think we have a question here from Justice Ramesh. We might start with you.
Just a comment. I think it's a fallacy to think that the idea of court-to-court communication has to come from the judge. I think it's important to remember, as we read the Cheng guidelines, the first paragraph actually, it's for the parties to raise to the court whether they think there should be a protocol, whether it's in the form of a memorandum or an order, that court-to-court communication should happen. So in a situation where you are seeking to, where it is desirable to communicate with a jurisdiction which does not have a natural leaning towards court-to-court communication, it's for the parties and therefore the advisors to take a view as to whether that's a sensible course to take. And if so, raise it to the court, which will then make the formal request through the appropriate channels. And obviously you can make an application in jurisdiction X for protocol to be initiated, and then the process gets kicked off. And if you look at the GIN guidelines, the last, I think it's guideline 13, if I remember correctly, it does provide, that's an option when we adopt the guidelines, that does provide for joint hearings as well. So there's a specific process, and Justice Sontchi referred to the modalities. Modalities are important because the modalities actually tell you how you actually initiate the process of communication, the nuts and bolts, as it were. Who do you call, who do you actually pick up the phone and say, look, I want to start the process of communication, what's the channel through which you speak. so to speak. So it's really, you need to understand that there's a will, there's a way.
Innovation driven by the parties is hopefully the hallmark of the period ahead. And of course there was last year, and I think it in fact commenced in the year before, joint simultaneous hearings between the Australian Federal Court and the New Zealand High Court, which was the first time that had happened, and they even attempted a simultaneous appeal hearing as well. So these cases are interesting because I believe it's what propels forward the consideration of some of the innovation and the opportunity that exists within the very flexible frameworks that we have to work with. I think there was another question, so if you could please come to the microphone and just ask your question from there.
Andrew Chan, Alan Gladhill. I welcome, I think, the move to, do insolvency cases in the SICC. I think it's also good that we have foreign, if you like, lawyers coming in and what have you. But one of the things which has been said to be a benefit insofar as the SICC is concerned is that we can do conditional fee agreements. But the exceptions in the legal profession, conditional fee agreements regulations, essentially is targeted to proceedings in the SICC. In restructuring and insolvency, the difficulty that we actually have essentially is that a lot of those other parts of, if you like, restructuring have nothing to do with SICC. So if I have a situation where I need to go to SICC, and I also need to go to some other jurisdiction, and so happens that SICC, if you like, portion stops, I can no longer do my conditional fee arrangement. The point which I'm essentially raising is this, because in some other jurisdictions, they have less restrictions when it comes to contingency, insofar as the lawyers are concerned, when it comes to contingency and conditional fee agreements. Those particular lawyers can come to Singapore, they can appear before the SICC, they can do conditional fee agreements. We, on the other hand, can only do it in respect of our aspect of, we, the Singaporean Council, can only do it in respect of that proceedings before the SICC. So the two questions are this. One, what is the experience in other jurisdictions? Foreign lawyers, do they have the possibility of, if you like, coming to Singapore, coming to the United States, going to other particular jurisdictions and doing a conditional fee or contingency arrangements for all jurisdictions? Because we cannot for the reasons I've given. Second thing is this, because perhaps I'm not sure that this is the best forum, but maybe I'll just raise this. If anyone has got any thoughts, perhaps we could change our particular exception to enable the whole of restructuring and insolvency to be such that we Singapore lawyers would be able to do conditional fee agreements, very much like what is the case now for the arbitration CAFA. Okay, well,
Corinne, I guess you're a foreign practitioner here, and the question was about what foreign jurisdictions do with conditional fee agreements. So without getting too esoteric on a fee issue, do you have a perspective on that?
It is not that common because in our system, restructuring is a fee shifting statute in any event. So when you are the company side, you're paying for the creditors committee advisors as well. So there just is not the opportunity for the general practice to be involved in contingent fee arrangements. However, our law specifically provides that you can retain, and we do it on particular bilateral litigations, a contingency fee lawyer, but their fee has to be approved in advance. And so we permit it, but it seems to be more on the special subset of issues as opposed to the general restructuring.
Yeah, I agree. It sounds like your problem is really not a bankruptcy problem. Your problem is that any lawyer takes his or her ethical rules associated with where they're admitted with them no matter where they go. And if your ethical rules don't allow you to do conditional fee agreements just because you go to Singapore and they say you can take a conditional fee agreement, well, that's fine when you're in Singapore, but you got to remember the people back home have a right to tell you you're not doing the right thing. So just saying that people can come here and do a certain thing where your rules currently say you can't do the same if you go somewhere else, I think it's really an issue of changing your rules, and I have no comment on that.
Well, we began the day with a rules announcement. We've ended the day with a rules question. Today's discussion has been, of course, all about debt restructuring in the Asia Pacific, and a great opportunity to talk about, I still think, what really is innovation at the heart of it, and we've heard some great examples of that today. I'd really like you to join me in thanking the panel, Corinne Ball, Patrick Ang, Tai-Heng, and Judge Sontchi. And I think with that, Lawrence, I hand back to you after the marathon afternoon that we've had.
Thank you so much, Scott, for a wonderful, moderating a wonderful session, and the panelists for such wonderful interaction amongst all of you. We've come to the end of the day, as Scott has mentioned. Again, I would like to thank Scott and INSOL for being here all the way from Sydney on this one, Corinne for having made all the way, and also Judge Sontchi for having made themselves all the way here from the east coast of the US. I'm so glad that borders are open.